Darren, have you ever had any cases where there was a stop involving any illegal activity that you were able to dismiss?
Well, it's interesting that you ask because I believe in one of our most recent question and answer sessions, we talked about whether or not somebody could be pulled over if they weren't displaying any driving drunk characteristics. And so, for example, we talked about somebody coming out of a bar, and just because a police officer or law enforcement authority sees that they are leaving a nightclub or a bar or a party, is that enough to get pulled over? And the answer was absolutely not. And it was on the basis of the Fourth Amendment of the United States Constitution, which protects citizens of this country from unreasonable search and seizures. Not everyone knows even what that means. So let's just describe an example of a search and a seizure on a stop and frisk kind of a situation, okay? And even though we're not discussing stop and frisk today, we'll do that next time. I just want to give you some examples to understand. A law enforcer who comes up to you and says, you know what, I'm going to detain you because I need to ask you a few questions, that is okay as long as he had probable cause to detain you. For example, he believes that there was a crime that was committed and you may be the person to commit that crime. And that's called a detention. An officer can detain you. And just to ask you, being so young and using a little bit of common sense, would a detention be the search part or would it be the seizure part of the United States Constitution's Fourth Amendment?
Detention, that would be the search part.
Incorrect. Okay, that's all right. No, it's all right because that means that some of our audience might get it wrong as well, right? It's seizing somebody's movement, right? They can't move because law enforcement has them detained, so that's the seizure part. Now, if they believed you were armed and dangerous, and they had probable cause to believe that, for example, a witness or the law enforcement officer himself saw you running from the scene of an armed robbery, and they know that the gun was being used at the robbery, can they pat you down? Is what's called frisking. Can they pat you down? The answer, okay, so you're redeeming yourself here.
Yeah.
The answer is yes, and that's true. Now, would that be the search or the seizure part?
That would be the search.
There you go. All right, we're back on track.
There we go.
So that's the search and seizure part. And we talked a little bit about stop and frisk, and last session we talked about being pulled over for a potential DUI. What I want to talk about today is an answer to your question. Can you challenge a stop even if illegal activity resulted from that bad stop? The answer is yes, you can challenge the stop. And as long as the stop was unconstitutional, meaning that there was an illegal, unlawful, unconstitutional search and seizure, then everything else flowing from that, what's called the fruit of the poisonous tree, is also spoiled. It means that nobody can take prosecution to the next level in terms of those charges if you were unconstitutionally stopped in the first place. So yes, I had a very great young man who was leaving work one evening, got a ride from his friend, and they were driving around going from his place of employment back to his house so that he could get dropped off at home. Unfortunately, they were driving through a crime suppression area. You have any idea what that might be?
Place where they would, I'm assuming, frequently stop more cars, frisk more people, search people.
Right. So there's a few other aspects of the law we'll discuss later for later sessions, which would be DUI checkpoints and also crime suppression units or crime suppression areas. Those get into the gray area of whether or not you can stop somebody with or without probable cause, and we'll get into that a little bit. But this was at the 110 and the 10 in downtown Los Angeles, and they were executing a crime suppression enforcement activity through that area. Our client was a passenger in a car, and his friend was driving in the driver's seat. So what happened is law enforcement was coming through on a car heading in one direction, and our client was traveling the same street but in the other direction. I read the police report, which resulted from an arrest on carrying a concealed weapon illegally in a car. And the police report said that the police officer saw our client being surprised that law enforcement was present, and therefore that was the probable cause for the stop. Being surprised that you see law enforcement when you're driving your own car and minding your own business, seeing if you're really on a roll here, is that a reason for law enforcement to stop you in the middle of the road?
No.
Okay, you're correct about that as well. More interestingly, the person who wrote the statement was the passenger officer of the law enforcement vehicle, and our client was the passenger of the subject vehicle. So they are in the furthest juxtaposed position possible as they're driving past each other. and it was at night. Our client was in a black car with black seats, black seat belt, and a black hoodie on. And the description the officer used to pull these people over as a reasonable, articulable excuse for suspicion that a crime had been committed and he committed the crime, or that there was a crime occurring in the car, was simply this. They said our client's mouth was agape and his eyebrows were raised. I'm not a comedian. I can't really show you exactly what that would look like. I don't do great impressions or impersonations, but it would be something like this. Being surprised the police officer is going. Now, at 9:30 at night, can you possibly even see into another car that's driving the other way that has your own partner in front of you and the driver of the subject car in front of you blocking your view and into a passenger seat when you have headlights that are also distracting your view? Well, I wasn't sure. So I sent out our investigator. He simply took out an iPhone at the same time at night, drove past another car that was similar in terms of being black and black seats and dark outside and black seat belts and black hoodie. You can't tell. But even if he was able to see somebody's mouth agape and eyebrows raised, that's not enough to be pulled over in terms of a crime suppression unit or probable cause whatsoever. Now, when this young man was charged, they were trying to put him away for 6 years in state prison. And it was as real as it could get. The gun was found under his seat. And they believed that he had that gun in his possession because it was found under his seat. And they arrested him. He had to pay a lot of money for bail. He had to pay, of course, a lot of money for legal services. And then, fortunately, he met me, my law firm, and my team. And for about 7-8 months there, it was looking a little hairy because the prosecution wasn't willing to dismiss the case until we showed them the conclusions of our own investigations, and we proved to them that this investigation was the result of fruit of a poisonous tree. Guess what the result was?
It was dismissed.
All right, so you answered all the remaining questions correct, which means that you're invited into a next round. And I can't wait to look forward to discussing more of these legal issues with you and our audience.
Sounds great.
All right, Chad, thank you very much.